Okay, 2 minutes completed. We are going to start the class. So, in the previous class, we observed the introduction about the Companies Act 2013, as well as definition of the company, classification of the company, and what are the characteristics of the company. Also, yesterday we completed the topics. Today, we are going to know about the steps and procedure for incorporation of the company. In that, the first one is a incorporation of company. This is the first step to establish or formation or registration of a company. So first, a company comes into existence is generally by a process which referred as incorporation. So what is the meaning of incorporation? It means a company comes into existence is generally by a process which referred as incorporation. So once company has legally incorporated, it becomes a distinct entity from those who invest their paid capital and labor to run the company. The first step from form a company is the process known as promotion, where a person persuades others to contribute capital to a proposed company before its incorporation. Such a person is called promoter of the company. Promoters also can enter into a contract on behalf of a company before or after it has been granted a certificate of incorporation and arrange the issues of shares in the name of the company. So before formation of the company, all of us who are going to take care those persons we call as the promoters, and they can issue the shares on behalf of the company before or after the formation of the company. So according to section 3 222 of the Companies Act 2013 is read as Companies Incorporation Rules 2014. So what are the sections provided in the Companies Act 2013? From section 3 to 22, they separately called as Companies Incorporation Rules 2014 and it made under the chapter 2 of the Act and which covers the provisions with regard to incorporation of companies and matters incidentally thereto. In terms of section 3 of 1, a company may be formed for any lawful purpose. 7 or more persons where the company to be formed is to be a public company. So whenever you want to start a form a public company, the required number of members is 7. 2 or more persons where the company to be formed is to be a private company. So what is the minimum number of members in public company? 7 members. And what is the minimum number of members in the private company? Is 2. But already we know that there is a OPC is also there, one person company, where the company is formed to be OPC, that is to say a private company. By subscribing their names or his name to a memorandum and complying with the requirements of this act. So what are the procedural aspects with regard to the incorporation? The first step, we have to obtain the digital signatures. So nowadays, various documents which is prescribed under the Companies Act 2013 are required to be filed with the digital signature of the managing director or member or secretary of the company. Therefore, it is compulsory required to obtain a digital signature certificate from authorized digital signature certificate issuing authority for at least one director to sign the e-forms, electronic forms, which related to incorporate, like the incorporation form 1 and other documents. Nowadays, due to the digital India concept, so all the signatures first we have to digitalize it. And we have to obtain the digital signature certificate from the authorized digital signature certificate issuing authority. Second one, obtain director identification number. I think most of the students know about the PAN card. permanent account number like that. Here also every director have to register their names and they can get the one number DIN number, that is a director identification number. So according to the section 153 of the Companies Act 2013, every individual intending to be appointed as director of a company shall make an application for allotment of director identification number in the form DIR 3 to the central government in such form and manner, and along with the fees also you have to pay. Therefore, before submission of e-form incorporation one, for availability of name, whenever you want to put one name for your company, first you can check whether the name availability or not. All the directors of the proposed company must ensure that they are having DIN, and if they are not having, first we have to obtain. So what is the first one? You have to obtain the digital signatures, and second step, every directors who are going to appoint it, they have to must have valid director identification number according to section 153. Third one, application for availability of name of company. So as per section 4 of 4, a person may make an application in such form and manner and accompanied by such fees also to the registrar for the reservation of a name set out in the application. So here two accepts are there. One, the name of the proposal company or the name to which the company proposes to change its name. As per the Rule 9 of Companies Incorporation Rules 2014, an application for the reservation of a name shall be made in the form of Incorporation 1 along with the fees provided in the company's registration offices and fees rules 2014. So here you can observe Rule 9 of Companies Incorporation Rules 2014, but here Companies Registration Officers and Fees Rules 2014. So what is the need for the application of availability of name of company? Because there is number of companies already registered. To avoid duplication in the name of the companies, first we have to check whether the name is available or not. Fourth one, this is a very important aspect in the form of incorporation of companies, that is preparation of memorandum of association and articles of association. So here we can consider two parts. One is the memorandum of association and second one is the articles of association. First one, memorandum of association. The memorandum of association is the charter of a company. It is a document which, amongst other things, which defines the area within which the company can operate. It is nothing but a constitution of the company. And the first step in the formation of a company is to prepare a document that is called as a memorandum of association. In fact, memorandum is one of the most essential prerequisites for incorporating any form of company under this act. According to section 4 of 6 of the Companies Act provides that the memorandum of association should be in any of the forms which is specified in the tables A, B, C, D and E of Schedule 1 of this Act. It may be applicable in relation to the type of company which is proposed to be incorporated or in the form as near thereto as the circumstances admit. So what are the things we are going to mention in the memorandum of association is provided in section 4 of 1. What are those? Name class, situation class, object class, liability class, capital class, and in the case of a one person company, the name of the person who, in the event of the death of the subscriber, shall become the member of the company also. We have to mention, and this all comes under we call about the memorandum of association. And the second part is the articles of association. According to section 2 of 5 of the Companies Act 2013, article means articles of association of a company as originally framed or altered from time to time or applied in pursuance of any previous company law or this act. These articles of the company shall be respective forms specified in the tables F, G, H, I, and J in Schedule 1 as may be applicable to the companies. And fifth one, filing of documents. So section 7 of 1, that the following documents and information for registration shall be filed with the registrar within whose jurisdiction the registered office of a company is proposed to be situated. So those are memorandum and articles of association of the company, as well as there must be duly signed. Section 7 of 1 of A states that memorandum and articles of the company duly signed by all the subscribers to the memorandum in such manner as may be prescribed, as well as they have to give an declaration also. Coming to section 7 of 1 of B states that a declaration in the prescribed form by an advocate, a chartered account, cost account, or company secretary who are in practice. And sixth one is a issue of certificate of incorporation by registrar. So, if after filing the required forms for incorporation with the register of companies along with the fees, the register of companies is satisfied with the contents of the documents which we filed, ROC will issue the certificate of incorporation in the form number INC 11 as directed by Rule 18 of Companies Incorporation Rules 2014. So after submission of your documents and pay the respective fee, the ROC is satisfied, then they will issue the certificate of incorporation in the form of INC 11, which the rules mentioned in Rule 18 of Companies Incorporation Rules 2014. On which date the company got the certificate of incorporation, on the date we can consider as a date of birth of the company. Seventh one, declaration at the time of commencement of business. So according to Rule 24 of the Companies Incorporation Rules 2014, the declaration filed by a director shall in the form number INC 21 along with the fees as well as the contents of the form shall be verified by a company secretary who are in practice or a chartered accountant or a cost accountant who are in practice, provided that in the case of a company which requiring the registration forms, sectorial regulations such as the Reserve Bank of India, Security Exchange Board of India, etc., the approval from such regulator shall be required. So, what is the meaning of the regulators? RBI. Whenever you are going to establish a non-banking financial institution or a banking financial institution, we have to get the permission from the RBI. Whenever you are going to list it into the stock market, you have to get the permission from the Securities and Exchange Board of India. And conclusive evidence. A certificate of incorporation given by the registrar in respect of any association shall be conclusive evidence that all the requirements of the Act have been compiled with in respect of registration and matters precedent and incidental thereto, and that the association is a company authorized to be registered and duly registered under the Act. So, the steps and procedure of incorporation of company or registration of a company or formation of a company, there is 7 steps. Step 1, obtain the digital signatures. Step 2, obtain the director identification number. Step 3, application for availability of name of a company. Step 4, preparation of memorandum and articles of association. Step 5, filing of the documents. Step 6, issue of certificate of incorporation by the registrar. The last step, the declaration at the time of the commencement of business. And we can alter memorandum of association as well as the articles of association also. So section 13 of 1 of the Companies Act 2013 provides that we can alter the memorandum of association. So what are the things we can alter in the memorandum of association? It may be given here. First one, by changing its name. So according to section 13 of 2, we can change the name of the company. By altering it in regard to the state in which the registered office is to be situated. That means we can shift or we can relocate the registered office of the company between the states, and based on the section 13 of 4 and 7. We can alter its objects based on the section 13 of 1 and 9. We can alter its share capital, section 61. We reorganize its share capital, section 230 to 237, and we can reduce its capital based on the section 66. So these are the things we can alter, and whenever we alter the memorandum of association, we have to file one copy with the register of corporation. Sorry, register of corporation. Registration of alterations. So according to section 13 of 6 of A, which provides that a company shall, in relation to any alteration of its memorandum, we have to file with the registrar. So based on the one special resolution of section 13 of 1 as well as approval of the central government under section 13 of 2, if the alteration involves any change in the name of the company. So these are the information